Dear students, uh, now I am taking another important issue which relates to cruelty to the animals, which has to be happened in the various parts of the country in the pretense of preservation of conventions, cultures of that particular state. As the present case on the name of Animals Welfare Board of India versus A. Nagaraja and others, which was decided by the Supreme Court in 2014. And here we can say the present case concerned itself with an issue of seminal importance with regards to the rights of animal. Under our constitution, in connection with the conduct of one Jali Katu Bullock cart races, etc. Time to time, it's the Ministry of Environment, Forests and Climate Change as early in 1991 issued notification under Section 22 of the Prevention of Cruelty to the Animals Act, banning trainings and exhibitions of bears, monkeys, tigers, panthers, and dogs, which was challenged by the Indian circuses organizations before the Delhi High Court. But later a corrigendum was issued where dogs were excluded from the notification. Later, again Ministry of Environment, Forests issued a fresh notification dated on 11th of July 2011, specifically including bulls, also so as to ban their exhibition or training as performing animals. While this court was seized of the matter. Here, Ministry of Environment and Forests has now abruptly taken up the stand that though bulls have been included in the list of animals not to be exhibited or trained as performing animals, by notification of 11th June 2011, it has been pointed out that in order to strike a balance and safeguard in the interest of all stakeholders, including animals, and keeping in the mind the historical, cultural, and religious significance of the event, and with a view to ensure that no unnecessary pain or sufferings is caused to the animals, participants, as well as spectators, the government proposes to exempt bulls' participation in Jallikattu in the state of Tamil Nadu from the preview of the notification issued on 7th, 11th July 2011, subject to the guidelines, copy which has been provided along with the affidavit filed by the Deputy Secretary of Ministry of Forests, Ministry of Environment and Forests. It's the uh, Animal Welfare Board of India has taken up a stance that Jallikattu or bullock cart race conducted as such has no historical, cultural, or religious significance either in the state of Tamil Nadu or in the state of Maharashtra. And even assuming so, the welfare legislation like Prevention of Cruelty to Animals Act would supersede the same, being a parliamentary legislation. Here, animal uh, welfare boards of India also taken up the specific stand that the bulls involved in Jallikattu, bullock carts race, etc., are not performing animals within the meaning of Section 21 and 22 of the PCA Act, and that the Ministry of Environment and Forests, in any view, was justified in issuing the notification dated 11th July 2000 and banning the exhibition of bulls or training them from them as a performing animals on the accepting the stand taken by it before the Supreme Court. Further, it has been taken up the stand that here Tamil Nadu regulation of Jalkatu Act is repugnant to the provision of PCA Act, and the rules made thereunder state cannot give effect to it in the absence of the assent of President under Article 254 of the Indian Constitution of India, as all of you know, which talks about the concurrent powers, concurrent power uh, under Article 254. And further, Animal Welfare Boards of India also said that bulls which are forced to participate in the race are subjected to the considerable pain and suffering, which clearly violates Section 3 and Section 11, Clause 1, Clause A, and Clause M of Prevention of Cruelty to Animal Act, read with another important provision of the Constitution, that falls under Article 51A, Clause G, and Article 21 of the Constitution. Hence, exhibition or training them as a performing animals be completely banned. On the other hand, it was the organizers of the Jallikattu and bullock cart races, individually and collectively, took up the stand that these events takes place at the end of the harvest season, that is January and February, and sometimes during the temple festivals, which is traditionally and closely associated with the village life, and especially in southern districts of the state of Tamil Nadu. Organizers of the bullock carts races in the state of Maharashtra also took the same stand, and the same is going on for the last more than 300 years by way of customs and traditions, and the extreme care and protection are being taken not to cause any injury or pain to the bullocks which participates in the event. Organizers also submitted that such sports events attract a large number of persons, which generates revenue for the state as well as enjoyment to the participants. Further, it was also stated that no cruelty is meted out to the performing bulls in bullock carts. This is as to violation of Section 11, Clause 1, Clause A of the PCA Act, and district collector, police officials, etc., are always on duty to prevent cruelty on animals. Further, it is also their strength that these sports events can only be regulated and not completely prohibited. And the state of Tamil Nadu has already enacted this TNRJ Act, which stands for Tamil Nadu Regulation of Jallikattu Act, which takes care of the apprehension of expressed by the votes. Here, the state of Tamil Nadu has also taken to the stand that every effort shall be made to see that bulls are not subjected to any cruelty so as to violate the provision of PCA Act, and the sporting event cannot be regulated as per the provision of uh, Tamil Nadu regulations to Jalkatu Act. Further, it was also pointed out that bulls taking part in Jallikattu, bullock cart race, etc., are specifically identified, trained, and nourished uh, for the purpose of the said sports event, and owners of the bulls spend considerable money for training, maintenance, and upkeep of the bulls. Further, the state has also taken up the stand that bulls are performing animals, and since there is no sale of tickets in the events conducted, so Section 22 will not apply. Will not apply. Uh, so also the notification dated 11th July 2011. So the state has also taken the stand that complete ban on such races would not be in public interest, and which is being conducted after harvest seasons and sometimes during temple festival as well. The state of Maharashtra has not challenged the Bombay High Court, hence the state of Maharashtra is in favor of banning the exhibition or training of bulls, whether castrated or otherwise, as a performing animals. Now, the argument which was advanced by Sri Raj Panjwani, learned senior counsel, appearing for the Animal Welfare Board of India, as well as for the petitioner in writ petition number 145 of 2011, submitted that event Jalkatu, even if conducted following the regulations of TNJR, Tamil Nadu regulations, or Tamil Nadu Jallikattu Regulations Act, would still violate the provision of PCA Act, especially Section 11, Clause 1, Clause A. Learned senior counsel submitted that Jallikattu as an event involves causing the bull pain and sufferings and cannot free from cruelty, and hence falls within the uh, meaning of Section 11, Clause 1, Clause A. Further, it was pointed out that during Jallikattu, the bulls, it is observed, carry out a flight response indicating both fear and pain and suffering. And Sri Panjwani made a considerable stress on the words otherwise, otherwise, which was used in section 11, clause 1, clause A, and submitted that any act which inflicts unnecessary pain or suffering on an animal is prohibited unless it is specifically permitted under any of the provision of PCA Act or the rules under uh, made thereunder. Sri Panjwani also submitted that since the event Jallikattu as such is an offence, that is an offence under section 11 clause 1 clause A, through a state act it can neither be permitted nor regulate it, and hence the act is void under Article 254, Clause 1 of the Constitution, and in the absence of any presidential assent. Another senior, uh, senior learned senior counsel, Sri Rakesh Dwivedi, who appeared for state of Tamil Nadu and uh, referring to the section 11 clause 3 of PCA Act, submitted that Act does not prohibit the infliction of all forms of pain or suffering on animals. Hence, section 11 clause 1 has to be read and understood in that context, referring to section 11 clause 1 clause A and subclause G, H, J, M, and N. Learned counsel submitted that the expression unnecessary pain or suffering is not used those clauses, and hence the events like Jallikattu, which do not cause that much of pain or suffering on the animals, cannot be completely prohibited, but would only be regulated. And as you know that it's the Tamil Nadu government uh, which has introduced one one act, that was the Tamil Nadu regulation of Jallikattu Act. On another learned senior counsel, it was Sri Bali, appearing for the organizers, highlighted that historical and cultural importance of Jallikattu event and submitted that taking into consideration the nature of event, the same would not be cause any unnecessary pain or suffering to the bulls which participates in the event so as to violate section 3 of section 3 or section 11 clause 1 clause A of the PC Act. Learned senior counsel submitted that such events could be regulated under the regulations framed under TNRJ Act, as well as the additional safeguards taken by the state governments and the proposed guidelines framed by the Ministry of Environment and Forest. Learned Senior Council also submitted that the mere fact that there has been some violation of regulations would not mean that the entire event is banned in the state of Tamil Nadu, which, according to the Learned Council, will not be in public interest. Learned Council also referred to the manner in which such events are being conducted world over after taking proper precautions for the safety of the animals used in those events. So, what was the issue before the court? Whether the events are being conducted in the state of Tamil Nadu and Maharashtra are in violation of Section 3, Section 3, Section 11, Clause 1, Clause A, and Clause M, and Section 21 and 22 of PCA Act, read with Articles 51G and H of the Constitution, and the notification dated 11 July 2011. Now, uh, after referring all these provisions which has been mentioned in PCA Act, and in spite of the various directions issued by the courts in the conduct of Jallikattu, bull courts, race, etc., the regulatory provisions of TNRJ Act and the restrictions in state of Maharashtra, the situation is the same, and no action is being taken by the police, collectors, district collectors, police officials and others who are in charge to control the same, to see that those directions are properly and effectively complied with, and the animals are not being subjected to torture and cruelty, being dumb and helpless, they suffer in silence. So the PCA Act 1960 was enacted so as to prevent the infliction of unnecessary pain or sufferings on animals and to amend the law relating to the prevention of cruelty to the animals. Now, in case if we talk about section 30, 30 of Act deals with the duties of the persons having having charge of animals, which is mandatory in nature, hence confer corresponding rights, because it's the duty of the owner to honor which mandatory in nature, and in case if duty is imposed by the section 3 of PCA Act, then obviously animals are animals have been conferred a corresponding right on animals. So rights so conferred on animals, thus the antithesis of duty, and if those rights are violated, the law will enforce those rights with legal sanction. And it was also mentioned that two limbs in section 3 have to be cumulatively satisfied. Primary duty on the person in charge of care of the animal is to be ensure to well-being of the animals. Well-being means the state of being comfortable, healthy, and happy. Organizers of the Zalikatus are depriving the rights granted to the bulls under Section 3 of the PCA Act. And in PCA Act, Jallikattu bullock carts race as much is not for the well-being of the animals, and by undertaking such events, organizers are clearly violating the first limb of the Section 3 of the PCA Act. And by organizing Jallikattu and bullock cart race, the organizers are not preventing the infliction of unnecessary pain or suffering, but they are inflicting pain and suffering on the bulls, which they are legally obliged to prevent. Section 3 is a preventive provisions casting no right on the organizer but only duties and obligations. So, Section 3, as already indicated, confers corresponding rights on the animals as persons, against the person in charge as well. Here, Animal Welfare Board of India, to ensure their well-being and be not inflicted with any unnecessary pain or suffering. Jallikattu or bullock carts race from the point of animal is not an event ensuring their well-being, and even uh, even meant to prevent the infliction of unnecessary pain or suffering. On the contrary, it is an event against their well-being and causes unnecessary pain and suffering on them. Hence, the two limbs of the Section 3 of the PC Act have been violated while conducting Jallikattu bullock cart race. And here the Section 11 generally deals with the cruelty to the animal. Section 11 confers no right on the organizers to conduct Jallikattu bullock cart races. Section 11 is a beneficial provision enacted for the welfare and protection of the animal, and it is penal in nature. So, being penal in nature, it confers rights on the animals and obligation on all persons, including those who are in charge of the care of the animals and animals, including animal welfare board, etc., to look after their well-being and welfare. So, Section 11 clause 1 clause uses the expression of otherwise, to which the legislature has intended to cover all situation where animals are subjected to unnecessary pains or suffering. So, reports submitted by the Animal Welfare Board of India clearly indicate that bulls are being treated with extreme cruelty and suffering, violating the provision of Section 11, Clause 1 of the PCA Act, uh, over and above Section 11, Clause 1, Clause B to Clause O, also confer various duties and obligations, generally and specifically, on the persons in charge or care of animals, which in return confer corresponding rights on animals, which, if violated, are punishable under the proviso to Section 11, Clause 1 of the PCA. So, Section 11, Clause 3 carves out exception in five categories, and all those five categories that in as and when there is a case of the horning of the cattle, castration, branding, or nose roping of any animals in prescribed manner, or the destruction of the stray dogs in lethal chambers or by such other methods as may be prescribed, and the extermination of or destruction of animal under the authority of law for the time being in force, or any matter dealt with the chapter fourth. The commission or omission of any act in the course of the destruction or the preparation for destruction of any animal as food for baking, unless such destruction or preparation was accompanied by the infliction of necessary pain or suffering. So exceptions are incorporated based on the doctrine of necessity. But entertainment, exhibition, amusement do not fall under these exempted category and cannot be claimed as a matter of right under the doctrine of necessity. So we can say that as the section 3 and 11 as already indicated, therefore conferred no right on the organizers of the Jallikattu or bull carts, but only duties, responsibilities, obligations, but confers corresponding rights on animals. Section 3, Section 11, Clause 1, Clause A, and Clause O, and other related provisions have to be understood and read with along with again Article 51A, Clause G of the Constitution, which cast fundamental duties on every citizen to have compassion for living creature. And Parliament, by incorporating Article 51A, Clause G, has again reiterated and re-emphasized the fundamental duties on human beings towards every living creature, which evidently takes in bulls as well. So bulls therefore cannot be performing animals, anatomically not designed for that, but are forced to perform, inflicting pain and suffering in total violation of Section 3 and Section 11 of the PCA Act, and Chapter 5th of the PCA Act deals with the performing animals. Section 22 of the PCA Act places the restriction of the exhibition and training of the animals. Section 23 of the PCA Act deals with the process for registration. Section 24 PCA Act deals with the powers of the court to prohibit or restrict exhibition, exhibition and training performing animals, and its section 25 of the act confers power on an authorized person to enter into the premises to examine as to whether the statutory requirements are properly complied with. Section 26 of the PCA Act deals with the offences, and Section 27 of PCA Act deals with the exemption performing animals rules. 1973 defines performing animals to mean any animals which is used for or for the purpose of any entertainment which publics are admitted through the sale of tickets. So Jallikattu carts races, it was conducted without the sale of the tickets, hence Section 22 or PCA Act would not apply. So also the notification, there is no substance of logic in that submission. So it may be noted that when bulls is specifically prohibited to be exhibited or trained for performance, the question whether such performance, exhibition, entertainment is conducted with the sale of tickets or not is irrelevant from the point of the application of Section 3 and Section 11, Clause 1 of the PC Act. And here uh, the power is conferred on the central government under Section 22 to ban the exhibition or training of any animals as performing animal following its earlier notification, which was issued on 14th October 1988, as already stated by the Ministry of Environment and Forest, issued under notification dated 2011, including bulls also an animal not to be exhibited or trained for exhibition as performing animal, which is conscious decision taken by the Ministry of Forest and Environment on relevant materials. So while this court was seized of the matter, the Animal Welfare Board advised under Section 9A and clause as well as the note of the Animal Welfare Division of Minister of Environment and Forest was accepted by the central government, and now it cannot take a contrary stance and take two without consulting the Animal Welfare Board of India, which advice was already accepted and acted upon. Uh, here, here, uh, here, you know that the some uh, provisions. So this PC Act has been enacted with an object to safeguard the welfare of the animals and evidently to cure some mischief and age-old practices so as to bring into the effect some types of reform based on eco-centric principles, recognizing the intrinsic value and worth of animals are the same. The Act has been care of religious practices of the community while killing an animal by Section 28 of the Act. So it was further unfortunately indicated that there is no international agreement that ensures the welfare and protection of animals. United Nations all these years safeguarded only the rights of human beings, not the rights of other species like animals, ignoring the fact that many of them, including bulls, are sacrificing their lives to alleviate human sufferings, combating diseases, and as food for human consumption. So, based on ecocentric principle, rights of animals have been recognized in various countries. For example, we can say that uh, the protection of animals has been guaranteed by the Constitution of Germany by way of amendment in 2002, when the words and animals were added to the constitutional clauses that oblige the state to respect animal dignity. Therefore, the dignity of animals is constitutionally recognized in that country, and other countries also, like Switzerland, Austria, Slovenia, have enacted a legislation to include animal welfare in their national constitution, so as to the balance the animal owners' uh, fundamental rights to property and animals' interest in the freedom from unnecessary pains, unnecessary pain or damage and fear. UK also confers considerable protection to the animals from pain and sufferings. Austrian Federation also uh, um, Austrian Federation Animal Protection Act also recognizes man's responsibility toward his fellow creatures, and subject federal act aims at the protection of life and well-being of the animals. And Norway also, the Animal Welfare Act of Norway states that animals have uh, an intrinsic value which is irrespective of the of the usable value that may have for the man. So further, the animal protection is also recognized under Universal Declaration of Animal Welfare UDAW, and World Society for the Protection of Animal, uh, and World Health Organization of Animal Health, to which India is a member. And it's the World Health Organization of Animal Health uh, recognize the five internationally recognized freedom for animals, such as freedom from hunger, thirst, and malnutrition, and freedom from fear and distress, and freedom from pain, injury, and disease, and freedom to express normal pattern of behavior. So, uh, animals are worldwide legally recognized property. So we can say the Food and Agriculture Organization, in its legislative and regulatory options for animals, indicated that these five freedoms found their places in Farm Welfare Council 2009 of UK, and and is also called Brumbell Five Freedoms. These five freedoms, as already indicated, are considered to be the fundamental principles of animal welfare, and we can say these freedoms find a place under Section 3 and Section 11 of PCA Act, Prevention of Cruelty Act to the Animals, and they are for animals like the rights guaranteed to the citizen of this country under Part Third Constitution of India, and they are like a uh, Magna Carta for the animals. So animals, the rights guaranteed under uh, the animals are worldwide legally recognized as a property that can be possessed by human on deletion of property rights, that is fundamental rights, Article 19, Clause 1, Clause F. Indian Constitution right to property is more with fundamental rights in India. This gives the Parliament more a freedom to pass laws protecting the rights of animals. So, right to hold on the property, which includes animals, also is now only a legal right, so not a fundamental right. So, we have also to see that rights of animal is this perspective also. So, rights guaranteed to animals under Section 311 are only statutory rights. So, same is to be elevated to the status of fundamental rights has been done by the few countries around the world. Now, Article 51, Clause A. Clause G states that it shall be the duty of the citizen to have compensation for the living creature. So, in case if we talk about the conflicts the between the TNRJ Act 2009, which was passed by the state legislature or state legislature of Tamil Nadu, and which is an anthropocentric legislation enacted not for the welfare of the animals, unlike PCA Act, which is an ecocentric legislation enacted to ensure the well-being and welfare of the animal and to prevent unnecessary pain or suffering of the animals. Uh, the State Act basically safeguard the interest of the organizers and spectators while conducting the event of Jallikattu. And that's why, in case if we compare the objects of Tamil Nadu regulations to Jallikattu Act, and its objects and reasons speaks of an ancient culture, tradition, also the safety of animals, participants, spectators, whereas PCA Act was enacted. Prevention of Cruelty Animal Act was enacted at a time when it was noticed that in order to reap maximum gains, the animals were being exploited by the human beings by using coercive methods, by inflicting unnecessary pain. So that's why The PCA Act was therefore passed to prevent the infliction of necessary pain or suffering and for the well-being and welfare of the animals, to preserve the natural instinct of the animal. Overpowering the performing animals was never in contemplation of PCA Act. In fact, under 3 Section 3 of the PCA Act, the statutory duty has been cast on the person who is in charge or care of animal to ensure the well-being of such animal and to prevent infliction on the animal of unnecessary pain or suffering. So this prevention of cruelty to the animal therefore casts not only duties on human being but also conferring corresponding rights on animals, which is being taken away by the State Act. State Act means Tamil Nadu, Tamil Nadu regulations to Jallikattu Act by conferring rights on the organizers and bull tamers to conduct Jallikattu, which is inconsistent in the direct collision with Section 3, Section 11, Clause 1, Clause A, Section 11, Clause 1, Clause M, Clause 2, and Section 22 of PCA Act, read with Articles 51A, Clause G, and H of the Constitution, and hence, or therefore, repugnant to the PCA Act or Prevention of Cruelty Act to the animal, which is welfare legislation and hence declared unconstitutional and void, being violation of Article 254 of the Constitution, as all of you know, that as and when if there is a conflict between the state legislation and central legislation under concurrent list, then it's the central legislation will prevail over the state legislation. So here the Supreme Court, uh, or thus we can say, uh, the Supreme Court held that the All India Welfare Board is right in its stand that Jallikattu, blue cards race, and such events per se violate Section 3, Section 11, and Section 3 and 11 of the PC Act, and hence we uphold the notification dated 11, 11th of July 2011 issued by the central governments. Consequently, bulls cannot be used as performing animals either for the Jallikattu events or bullock carts races in the state of Tamil Nadu or Maharashtra or elsewhere in the country. So, thus the Supreme Court has laid down the following declarations or directions. First, we declare that the rights guaranteed to the bulls under Section 3 and 11 of PCA Act, read with Article 51, Clause 1, 51, 51A, Clause G and H, are cannot be taken away or curtailed except under Section 11, Clause 3 and 28 of the PCA. And we declare that the five freedoms referred to earlier to be read into Sections 3 and 11 of the PC Act to be protected and safeguarded by the states, central government, union territories, or even Ministry of Environment and Forest, and by Animal Boards or Animal Welfare Board of India. So, Animal Board of India and governments are directed to take appropriate steps to see that the persons in charge or care of animals take reasonable measures to ensure the well-being of the animal. And Animal Welfare Board and government are directed to take steps to prevent the infliction of unnecessary pain or suffering on the animals, since their rights have been statutorily protected under Section 3 and 11 of the uh, prevention to prevention of cruelty to the animals act, and animal welfare act of India is also like to ensure that the provision of 11 scrupulously followed, meaning by that the person in charge or care of the animal shall not be incite any animal to fight against a human being or another animal. So, uh, animal welfare boards of India and governments would also see that even in the cases where Section 11 is involved, the animals were put to the necessary pain and sufferings, educate and scientific methods to adopt to achieve it. Uh, so, any the animal, the Parliament is also expected to make proper amendment of the PCA Act to provide an effective deterrent to achieve the object and purpose of the Act, and for violation of Section 11, adequate penalties and punishments should be imposed. Parliament, it is expected, uh, would elevate rights of animal to that of constitutional rights, as done as done by the many of the countries around the world, so as to protect their dignity and honor. The government would see if the provision of PCA Act and declaration and directions issued by this court are not properly and effectively uh, complied with. The disciplinary action is to be taken against the erring officials so that the purpose and object of PCA Act uh, could not be defeated or could be achieved. And the Tamil Nadu regulations to Jallikattu Act is found repugnant to the PCA Act, which is a welfare legislation, hence held constitutionally void, being violation of Article 254, Clause 1 of the Constitution. And All India Welfare Board, All India Welfare Animal Welfare Board of India is directed to take effective and speedy steps to implement the provisions of uh, PCA Act in consultation with SPCA, and make periodical reports to the government if any violation is noticed. So the government should take steps to remedy the same, including appropriate follow-up action. So thus the judgment of Madras High Court was set aside, and the judgment of Bombay High Court and notification dated 11th of July 2011 issued by the government were upheld. So it's all regarding this uh, landmark judgment, which was related to for the related to the, for the eliminate the sufferings and pains of animals, especially like the festivals like your Jallikattu, which was to be happened or which is being happened in Maharashtra and Tamil Nadu. So now the after this case, I am coming to another important development because of one landmark decision which was delivered by the Supreme Court related to article, although I have got covered the portion of article 16 clause 4, 16 clause 4a, and the 85th constitutional amendment, and all other relevant case law like M. Nagaraj, Lachiram, Pavitra, Jarnail Singh, etc. But now, on uh, April 17, 2020, means during this lockdown, the Supreme Court delivered one lecture or one decision which denied about the reservation in promotion along with consequential scenario. And here a one appeal was made by the appellants. It was the Pravakar, Malik, and others. And here the civil appeal is filed, agreed by the judgment and order dated 24th December 2010, passed by the High Court of Orissa at Cuttack in writ petition number 6781 of 2008. By the aforesaid order, a writ petition filed by the respondents number 4 to 8 herein is allowed by citing the order uh, dated 17th April 2008 passed in 2008 by the Odisha Administrative Tribunal and the government resolution dated uh, 20th March 2002 and consequential list dated 3rd of March 2008 of the Odisha Administrative Service Class 1 Junior branch are Quest. What was the background of this case? In view of the instruction issued by the Office of Memorandum dated 21st January 2002 by the Government of India, Minister of Personal Public Grievance and Pensions, the Government of Odisha has passed the resolution dated 20th March 2002. By the aforesaid resolution, while withdrawing the earlier instructions for fixation of seniority of the members of scheduled caste and scheduled tribes, government servants on promotion by virtue of rules of reservation, the state government has issued instructions to the effect of the catch-up principles adopted earlier by the state government in General Administration Department resolutions. As I think you know that we have got discussed all these catch-up rules also. So, in the light of catch-up principle adopted earlier, the state government in General Administration Department resolutions in 2000 shall not be followed any longer. So, it is further ordered that government servants belonging to the scheduled caste and scheduled tribe shall retain their seniority in case of promotion by virtue of the rule of reservation. And in the said government order, it is further clarified that the government servants belonging to the general category or uh, category promoted later will be placed junior to the scheduled caste and scheduled tribes government servants promoted earlier by virtue of the rule of reservation. The High Court has allowed the above mentioned writ petition and connected writ petitions and quashed the aforesaid government order and gradation list dated 3rd of March 2008, mainly on the ground that unless and until the state government makes a law for conferring the benefit of promotion with consequential seniority to the scheduled caste and scheduled tribe, they are not entitled to claim seniority in the promoted categories over the general category candidates. So the said writ petition is allowed following the judgment of M. Nagaraj. And the here now the respondents writ petitioners were appointed to the Orissa Administrative Services Administrative Services posts pursuant to the selections made by the Odisha Public Service Commission. They were recruited during the years of 1983, 84, and 1987. They were assigned different ranks in the merit list of their respective batches prepared by the Public Service Commission. In the above said merit, the persons belonging to the scheduled caste and scheduled tribes category, they were appointed against the reserved vacancies were placed below the writ petitioners. So thus the writ petitioners were senior to the appointee belonging to the scheduled caste and scheduled tribe category. So the respondent writ petitioners were subsequently promoted and appointed in the next higher scale, and that is Odisha Administrative Services Class 1 by the government notification dated 2026 uh, August 2000. The appellants and some other belonging to the scheduled caste and scheduled tribes category recruited along with the respondents writ petitioner in subsequent batches were given promotion uh, to the rank of Odisha Administrative uh, Services uh, Services Class 1 against reserved vacancies during the year 1995 and 2000 as provided under Odisha Reservation Vacancies and Post of Scheduled Castes and Scheduled Tribes Act 1975 and the rules made thereunder. The seniority of the reserved categories and unreserved categories, including that of respondent writ petitioners, was not finalized by the Public Service Commission since the principles determining the seniority inter was that subject the matter of several litigations. So the original seniority position in the cadre of Odisha Administrative Services prepared by the Odisha Public Service Commission was retained without any change in the view of the judgment of the court in the case of Virpal, Virpal Singh Chauhan, which was decided in uh, decided in 1996. Irrespective of the getting promotion in subsequent year, the inter-se seniority of the respondent writ petitioners and the scheduled caste and scheduled tribe roster point promotee in the rank of Odisha Administrative Services was maintained in the seniority list uh, prepared on 16th May 2001. And here Article 16(4)(a) of the Constitution was amended by 85th Constitutional Amendment and enabling the state to grant benefit or promotion with consequential seniority to scheduled caste reserved category candidate officers by 85th Constitutional Amendment. Article 16 clause 4a was amended for the words, as all of you know that we have got discussed it, in matters of promotion to any class. The words in matter of promotion with consequential seniority to any class were substituted. In judgment of the M. Nagaraj, the constitutional bench, while upholding the constitutional uh, upholding the constitutional validity of 85th Constitutional Amendment 2008 were held that the state is not bound. What was the ultimate crux of this decision? That state is not bound to make reservation for SC/ST in matter of promotions. However, it was held that if they wish to exercise their discretion and much so and make such provision, the state has to collect uh, quantifiable data showing backwardness of the class and inadequacy of the representation of that class in public employment. In addition to the compliance of Article 335 of the Constitution, which talks about the administrative efficiency, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling of 50% or obliterate the creamy layer or extend the reservation uh, indefinitely. So, in case of Virpal Singh Chauhan, as in case of Virpal Singh Chauhan, which was decided in 1996, this court has held that the reserved promoted candidates are not entitled to seniority in the promoted post, and if the general category candidates reaches the said post, he is entitled to seniority over the promotee to reserved category vacancies. Subsequently, it what happened that it was the three judge bench judgment in case of Jagdish Lal versus State of Haryana has held that this case was decided by the Supreme Court in 1997 that the reserved promoted category candidates are entitled to the seniority in promoted posts and not pursue the feeder cadre, means that as it was as they were getting the seniority from their initial appointments. Subsequently, then another development was happened as we could discuss this case. The constitutional bench of Supreme Court in case of Ajit Singh and others versus State of Punjab has overruled the Jagdish Lal case and upheld the principle of catch-up rule, which was propounded by the Supreme Court in the judgment of Virpal Singh Chauhan in 1996. So, in the view of the catch-up rule evolved by the court in case of Virpal Singh Chauhan, which is approved by this court, subsequently in the Ajit Singh 1999, the seniority list dated 16 May 2001 of the officers of Orissa administrative officer has been prepared. In such list, the roster appointee promotee belonging to the scheduled caste and scheduled tribe who were given promotion to Odisha Administrative Services against reserved vacancies earlier, irrespective of their original seniority in the feeder cadre, were shown below the respondent writ petitioner. So it is not in dispute that after 85th Constitutional Amendment, uh, amending Article 16 Clause 4A of the Constitution, the state of the Odisha has neither issued any executive order nor enacted any legislation for conferring benefit of seniority of officers belonging to the scheduled caste and scheduled tribes who were promoted against the reserved vacancies. Referring to the instructions issued by the Government of India, the state of Odisha has issued a resolution dated uh, 20th March 2002 issuing instructions to the all departments of the government to extend the benefit of seniority for scheduled caste and scheduled tribes government servants on promotion by virtue of the rule of reservation. Pursuant to such government resolution dated 20th March 2002, a gradation list was prepared by altering the seniority of the respondent writ petitioner. Uh, Writ petitioner means contrary to the uh, s- list of 16th May 2001 means it was altering the seniority of the respondent petitioner means the candidates of general category. So at the first instance, the respondent petitioner approached the Odisha Administrative Tribunal and by filing original application, but the said application was dismissed on the ground that it was a premature stage. So therefore, respondent petitioner have approached the High Court, questioning the order of tribunal uh, and sought further relief for uh, quashment of the government resolution and the consequential uh, gradation list. The writ petition is allowed by the common order in batches of the cases by the High Courts of Odisha, mainly on the ground that the government resolution dated 20th March 2002 can neither be termed as a law in exercise of enabling power of the state under Article 16 Clause 4A, nor does it satisfy the parameter laid down by this court. So the High Court further held that there is no legal basis for such resolution and accordingly quests the government resolution and consequential consequential gradation list. So now uh, we have heard Sri A. Subbarao, Learned Counsel, appearing for the appellant. Now, the appellant means the candidates of uh, reserved category. They moved to the Supreme Court, learned before the state, appearing for the appellants, learned counsel for the state of Orissa, and learned counsel representing one of the writ petitioner. Sri Subbarao, learned counsel appearing for the applicants, has primarily contended that as per the judgment of court in case of M. Nagaraj, this court has upheld the amendment of Article 16 Clause 4A of the Constitution by 85th Constitutional Amendment and held that it is always open for the state to extend the benefit of reservation with consequential seniority, either by executive order or by law, by the way of legislation. And the government has taken decision by the way of dated uh, resolution dated 20th March 2002. Same is quashed by the High Court without assigning any valid reasons. So it is further submitted that the Odisha Act 38 of 1975, that is the Odisha Reservation of Vacancies in Post and Services for Scheduled Caste and Scheduled Tribes Act of 1975, is in force. So in the state, by the said act, benefit of reservation has been extended to the Scheduled Caste and Scheduled Tribes. In promotions also, the Land Council has placed reliance on Section 10 of the said Act to buttress his submission that as per the same, the promoted scheduled caste and scheduled candidates are entitled to the benefit of seniority. The Learned Council, appearing for the state of Odisha, has fairly submitted that after 85th Constitutional Amendment, by which 16 clause 4 was amended, so there is neither any legislation in state of Odisha nor any executive order by the government to extend the benefit of promotion to the reserved vacancies with consequential seniority. So, having heard the learned counsel on the both sides, we have pursued the impugned order and other material on record. It is clear. It is clear One of the material placed on record that the seniority for general category officers was restored in gradation list, which was prepared on 16th May of 2001 by extending the benefit of catch-up rule evolved by the court in case of Virpal Singh Chauhan of 1996, and which is subsequently accepted in the case of uh, Ajit Singh after consequential after the 85th Constitu- 85th Constitutional Amendment Act 2001, which amended the Article 164A, and which said that nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to pass any class or classes or posts in the services under state in favor of scheduled caste and scheduled tribes, which in the opinion of the state are not adequately represented in services under the state. So the above said amended constitutional provision makes it clear that the case that in case the state is of opinion that scheduled castes and scheduled tribes are not adequately represented, the state is empowered to make the provision for reservation in matters of the promotion with consequential seniority to any class. When the validity of the constitutional amendments was questioned, same was upheld in the court of M. Nagaraj. So, in the aforesaid judgment, a constitutional bench of court has held that state is not bound to make reservation for scheduled castes and scheduled tribes in matter of promotion. However, if they wish to exercise their discretion, make reservation and promotion, and the state have to collect quantifiable data showing showing backwardness of the class and inadequacy of representation of class in public employment, and keeping in mind maintenance of efficiency under Article 335 as indicated by Article 335 of the Constitution. So it is further held that such exercise depends upon the availability of data. And in one case, which was decided by the Supreme Court in the case of Surjbhan Meena versus State of Rajasthan, the two-judge bench of this court has considered the validity of the notification providing for promotion of members of scheduled caste and scheduled tribe with consequential seniority issued by the state government. So, in the aforesaid judgment, it is held that the court that the need of the collecting quantifiable data and ascertaining the inadequacy of the representation members belong to the scheduled caste is a condition precedent for issuing notification providing benefit of reservation with the consequential seniority. Further, in another case, uh, as I got mentioned, there is this regarding this case also earlier also that we are having uh, two case which relates to the BK Pavitra versus BK Pavitra versus Union of India. In this case, held that the determination of inadequacy of representation, backwardness, and overall efficiency is the mandatory for exercising power under Article 16, clause Article 16, clause 4A. So it is further uh, held that said case that in mere fact that there is no proportionate representation in promotional posts for reserved category candidates. So by itself is not sufficient to extend the benefit of consequential seniority to promotee who were otherwise juniors. So it is held that the absence of such mandatory exercise by the state, the catch-up rule fully applies. See another case. It was the case of Jarnail Singh uh, versus Lakshmi Narayan Gupta. While answering the reference A constitutional bench of this court has held that the judgment in the case of M. Nagaraj need not to be revisited, need not to be revisited by referring to a seven-judge bench. So at the same time, it held that the conclusion in M. Nagaraj that the state has to collect a quantifiable data showing backwardness of the scheduled caste and scheduled tribes is held to be invalid on the ground that the same runs contrary to nine judge bench judgment of Indra Sahni versus Union of India, uh, in which you know that in Indra Sahni, as all of you know, that the Supreme Court had laid down one important guideline that there is no reservation in promotion. So it is also held that said judgment that Article 16 Clause 4A has been couched in language which would leave it to the states to determine adequate representation depending upon the promotional post in question. Further, in the case of B.K. Pavitra versus Union of India 2009, this court, while considering the validity of Karnataka determination of seniority of the government servants promoted on the basis of reservation to the post in the Civil Services of the State Act 2002, has upheld the act on the ground the same was enacted by making studying regarding inadequacy of the representation and overall administrative efficiency. So, in view of the judgments as referred above, in this instant case, it is to be noticed that after 85th Constitutional Amendment 2001, which amending the 16th 4A of the Constitution, which enabled the state to extend the benefit of reservation or benefit of promotion with consequential seniority by examining the adequacy of representation to the scheduled caste and scheduled tribe candidates uh, in the state services, the state of Orissa has not made any provision, either by the way of legislation or by the executive order, to extend such benefit in the class of class one services. So the advocate of state specifically admitted that the government has not issued any executive order or passed any legislation. So the government resolution dated uh, 20th March 2002 is issued by merely basis on the instructions issued by the government of India without examining the adequacy of the representation imposed. So as is evident from the order of High Court, the state in its counter affidavit has taken the stand that there is no necessity for bringing out any law to extend the benefit of seniority for those who were promoted to the reserved vacancies. Government resolution dated 20th March 2002 can neither be termed as a law made in exercise of enabling the power of state under Article 16, uh, 16 Clause 4A, nor does it satisfy the parameters laid down in the various decisions of the court. So the resolution has no legal basis. So the seniority or the gradation list dated 16th of May 2001 was prepared correctly by following the ratio laid down by this court. Following the ratio means following the rule, following the ratio of catch-up rule or the following the catch-up rule laid down by this court in the absence of any law of the decision by way of executive order based on acceptable material or conferring additional benefit of consequential seniority. So the gradation list prepared the gradation list prepared on the 3rd of March 2008 was prepared by altering the positions which were maintained in the list dated 16th May 2001, while it is open for the state to confer benefit even through an executive order by applying mandatory requirements as contemplated under 16.4a, but the resolution dated 20th March 2002 is merely issued by referring to the instruction of the Government of India without examining the adequacy of representation in promotion posts and held as held by this court. Further, the submission of the Learned Council, Sri A. Subharao, that the benefit of reservation in promotion is given in the services of Odisha Administrative Services for scheduled caste and scheduled tribe as per section 10 of the Odisha Act 38 of 1975, but same uh, cannot be countenanced for the reason that such act was enacted by the state Odisha in year of 1975. But no provision is brought to our notice in such act for giving the benefit of seniority for the promotees who were promoted in reserved vacancies, in absence of any provision in the said act for conferring the benefit of seniority and absence of any amendment constitution in absence of any amendment after 85th constitutional amendment by which article 16 clause 4a was amended, benefit of seniority cannot be extended relying on section 10 of the act. So in view of the stand of the respondent state in the counter affidavit filed in the writ petition, and further in view of the submission made by the Learned Council for the state of Orissa, that no benefit of seniority was extended by any state act or by any executive order. Extended by the state act means state legislation or state law, or by executive order by the by examining adequate representation in terms of Article 16 Clause 4 A of the Constitution. So we do not find any merit. Here the court held that we do not find any merit in this appeal so as to interfere with the well reasoned judgment of the High Court. So the judgment of this court rendered in the case of Jarnail Singh relied on the learned counsel for the appellants, also would not take any further the case of appellants in the said judgment, also for giving the benefit of promotion with consequential seniority, the need to examine adequate representation imposed in terms of judgment of this court in case of M. Nagaraj is maintained. So, as such, the said judgment would render would not render any assistance for the case of appellants. So, for the aforesaid reasons, the appeal is dismissed with no order as to cause. And the appellants of this appeal, who are not parties before the High Court, have also sought the same relief as has been sought in civil appeal. In view of the dismissal of this appeal, so appeals also stands dismissed. And you know that it was the another development with regards to the consequential seniority with, in the light of latest judgment which was delivered by the apex court on 17th April 2002. So it's all regarding the present discussion which relates to Article 16, or rather Article amended Article 16.4a of the Constitution. Thank you. And again, I would like to make a request that in case if any kind of doubts or queries or question, please ask Mr. Mann or Mr. Agarwal to arrange a meeting on Zoom or on video conferencing. Thank you, all of you.